This is Marigona Benalkai. I am a family law clerk and a family mediator in training with Benmor Family Law Group. In today's interview, Stephen Benmor will be discussing and elaborating on what constitutes an emergency in family court, as recently the courthouses in Ontario have suspended all non-urgent matters until June, and we know that this has caused a lot of worry and raised a lot of questions. Mr. Benmor, I pass it over to you to now further explain to our viewers.
Thank you very much. So in the last 2 weeks, there has been a real debate on what the courts will in fact consider dealing with divorce matters. Up until a couple days ago, people were pretty much in the dark. They didn't know. But in the last few days, there's been a number of court decisions released where judges have either determined that the level of emergency was not met, in which case the judges did not consider the request for relief. And in some cases, the judges have determined that the threshold has been met, determining that the case is an emergency that requires their involvement. The courts have consistently said that financial matters are not emergencies, although just this week, there were a number of cases where the judges said without some financial relief, it raises the level of emergency. But for the most part, the cases that have actually made it through the gate for judges to deal with it by way of emergency during this period of coronavirus pandemic have related to the withholding of children. So for example, where there have been court orders that specifically state that a child should be with the parents on a particular schedule, and one parent has withheld the child, refused to return the child to the other parent, pursuant to the court order or a separation agreement, in those cases, the courts have indeed accepted the emergency motion and have either directly dealt with it or have scheduled a remote phone call motion where both parents are able to participate, resulting in the judge making a decision. So what has historically been the case in terms of what is an emergency has been narrowed. There clearly are fewer cases that are meeting the test, but the fact of the matter is, as of today, the idea of withholding a child from one of their parents is considered an emergency, and in some cases the judges will consider it. Not in all cases will the judges grant the relief requested, but it seems as though as of today, withholding a child is an emergency, particularly if there's a court order or separation agreement that provides otherwise. I hope that helps. And if you have any other questions, feel free to ask.